Okay, yeah, so TLDR, right? TLDR is the plaintiffs are opposing the motion to stay discovery. The defense put in a motion trying to delay the discovery process because it's going to be time-consuming and cost-intensive. It's going to be expensive. Discovery is going to be several $100,000 to get all the documentation that they need. They have to put together binders. They have to have a meeting, multiple meetings with like both sides of both sets of counselors. They all come together at a table with the judge, and they're going to talk about like all the things that they're going to go and get, and then the discovery process is going and getting them. That process will take probably 6 fucking months, and it's going to be hundreds, if not thousands, of man hours to translate all of the stuff that is relevant to be translated. There is a pending motion to have this case removed from United States court because it's being litigated in Korea at the exact same time. The Korean case is ahead of the United States case. There was a response to, so Nexon argued or tried to argue that it shouldn't be dismissed because of a bad forum or a shitty forum, because mainly because in the DMCA, when somebody disputes the DMCA with a place like Steam, Valve, whatever, they consent to the authority of the court in the area around, like in this case, Valve. So the Seattle, Washington court, the Ninth Circuit court, they tried to argue, the Ninth District Court, whatever, they tried to argue that that statement saying that they recognize the jurisdiction of the court meant that they were agreeing to the forum in Seattle being the best possible place to hear the case. But that's not true. There's prior case law where the argument that was made by Iron Mace to go against this is that the forum that you're agreeing to isn't being agreed to in the DMCA dispute. It's being, you're agreeing to personal jurisdiction, meaning that you recognize that the court has authority to be able to make those decisions based on like what they're going to allow you to do, what rights you have. So like the right to be able to do business, for example. So if the Ninth Circuit Court were to come in through this trial, once it got there, if it gets there, and say like, Iron Mace has the ability to do business however the fuck they want, it goes back on Steam, get fucked Nexon, then everybody agrees that that ruling stands, right? Like that's how it works. Now there's appeal processes and all that shit, but that's basically what you're agreeing to with the DMCA. You're saying that this court has the jurisdiction to be able to make those choices. But what Iron Mace argued is that that isn't them admitting that the forum is good. Like the best possible place to have the case heard isn't necessarily in Seattle when all of the relevant parties and the witnesses and the testimony and all of the notes and everything else that have been taken, you know, email trails, all that stuff is all in Korean and would need to be translated from Korean and certified as accurate, being translated from Korean into English, which all of it would have to be. And the defense doesn't have anyone that speaks Korean as part of the legal team. They have experts on the outside that do, but again, those people have to be paid. And when you've got 5,000 pages of documentation, the vast majority of which are in Korean, that's a lot of man hours. And you're gonna need teams of people to go through all of those pieces of documentation. On top of all the time that the lawyers spend, you're looking at hundreds of thousands of dollars. I don't see how it wouldn't be hundreds of grand. So Nexon has come back and they say, well, no, this entire thing, this reply that Iron Mace made saying that none of our arguments are valid because we poked a bunch of holes or tried to poke a bunch of holes in Iron Mace's original dismissal. And when Iron Mace came back and said, well, that none of that's actually true because you could have done these things and we have this expert that's going against what your guy is saying. What they're doing is saying, well, all of that is fine, but you showed up with this kind of at the 11th hour and you didn't tell us that this was coming and you didn't submit this in your original motion. So it should all be struck from the record because we didn't know that you guys were going to go and do this. When in reality, what really happened in my mind is that Nexon made all the arguments that they did. And then Iron Mace went and found outside sources to be able to argue against their arguments because Nexon tried to poke a bunch of holes in Iron Mace's shit. And then I think that they did that handedly. I think Iron Mace fucked Nexon. I think that Nexon got ravaged by the arguments that Aaron Moss made. So now we have this, which is them saying that, basically reiterating the points that they made before, but also trying to compound this by saying that we didn't know that this was coming, so you should just throw it out to the judge. Like the entire reply that Iron Mace had just made, you should strike it completely. None of that should count, and here's the reasons why. And then they just reiterate their positions over again, which again were like completely destroyed by Aaron Moss's argument. And I don't think that this is going to hold any water at all. I think this is like some of the weakest shit I've read come from them. one of the other things that they did is Iron Mace requested that like I said, they requested the discovery get delayed, and then the plaintiff opposes that, and they're saying that they don't want the discovery to get slowed down because it's in the best interest of the plaintiff and the court and the entire process to have this expedited as fast as possible, because Iron Mace is going to monetize their game and they're going to try and make money on it. They're still working on their game because they haven't been ordered not to work on their game anymore. So, oh God, like did you see what happened? The guy that does concrete work for a living, well, somebody's suing him for bad concrete work. And oh my gosh, he got up this morning, put on his boots, and he went and poured concrete today. The gall of that man, right? Like, this is what they do for a living. They're going to go to fucking work and work on their shit until they're told not to. Like, fuck off. Then they cite a whole bunch of case law, and they try to say that the financial burden that Iron Mace is claiming is not real. It's fabricated because they must have financial backing because there's 30 people that are working for the office at the same time and they haven't made any money off of their game, which is probably true. They do have some financial backing. I would assume that they do. Unless Terry is a fucking millionaire, but I don't think he is. I think that these guys have some amount of financial backing, or like maybe they're making cheats or some shit. I don't fucking know. Maybe they got like one of those $10,000 a month cheats that they're marketing to a bunch of gamers. Maybe they're selling Tarkov cheats. Fuck. I mean, I heard it's lucrative. And it's probably not true. I'm only kidding. I'm only kidding. I'm only kidding. All right. But they're saying that they have financial backing at some level. But Nexon's arguments are very assumptive. Throughout the entire read of this, they're assuming that they have certain access to certain things. They assume that they must have financial backing with extremely deep pockets, is how they ended up wording it, by saying like, well, they've got 30 devs that are working on this thing. They must have shit tons of money. And they're saying that they're fabricating a lot of the stuff that they're coming up with and making like bad arguments and all this other jive. Again, though, in my opinion, the arguments that are being made here, and I'm trying to stay relatively unbiased, but the way that this reads is like Nexon is just bullying at this point. And it looks like this is a hard attempt to just drag the case on as long as they possibly can for those two beautiful magic words that every lawyer loves to hear: billable hours. That's how it reads. And it's unsettling to me to read some of this the way that it has been portrayed, because it looks like the attorneys for the plaintiffs are just ignoring like existing case law and precedents that have been set. And they've done it now like 3 times in one particular instance. So like, yeah, it's really, really weird what they've decided to try and argue in this case. And I personally don't see the judge siding with these guys at all on the stuff that they've cited. I think that the stuff that they've cited is extremely weak, and the only chance Nexon would have in this case would be for the judge to grant the striking of the reply to the opposition that they made before, and say that Iron Mace, came out of left field with the stuff that they did. But I don't think they did. I think that they were just responding to the stuff that Nexon alleged by providing additional evidence, because Nexon was trying to poke holes in their argument, instead of them just being like, well, here's a bombarding amount of stuff to like go on top of this. They probably didn't realize that Nexon was going to argue over a 2-word phrase. And then, like, I think the last thought I have on this, like for TLDR purposes, is that they're again arguing over a 2-word phrase about like this relating to with the personal contracts about the employees and stuff. And then I would just go back in the old YouTube videos and look at the stuff that I did from like the last one. Their argument is like, well, this stuff would be readily available, and like they make an assumption on whether or not Iron Mace would have access to experts that could translate irrelevant documentation, because who are they to say what's relevant and not relevant? But whatever. The thing that kind of like chaps me a little bit about this is that they're already arguing over a 2-word phrase in several motions and counter motions, and like arguments and counter arguments, like several times over a 2-word phrase as it pertains to the law in the United States, as if this wouldn't be the theme for the remainder of the entire case over who knows how many years worth of litigating would go on, where these guys are going to be going back and forth over what phrase is supposed to be used where and why, and the experts backing up certain verbiage on one side or the other, and like what's certified and what needs to be argued over certification. Like that by itself will end up taking up months, 6 months, probably worth the time where they're going to argue over whether or not a certain person wrote a certain thing a certain way as it's translated into English. Like, it looks like it's just going to be like this long, horribly drawn out process when the entire thing could just be argued in Korea, and then you wait and see what Korea is going to do on their preliminary injunction. And if they side against Iron Mace, the whole thing stops anyway. So what's the point? I just don't understand. But that's, yeah, I think that's it. It just reads like salt, man. I don't get it. I don't get it at all. It's just salt. Right, like that's the other thing. Like financially, right? Like I don't know about you all. Like I've started businesses before. I've had people that worked for me before. Like I started a painting company. I had 7 guys that worked for me. I had 3 vehicles. You know, working as a contractor, doing commercial rental properties. I had at one point in time I had 680 rental units that I was responsible for, doing property maintenance and commercial painting. And dude, it was skeleton crew shit, right? Like I paid the guys fair. I thought I was always fair, but it's not like, dude, it's not like we had health benefits packages. You know, like they were going to the fucking marketplace to figure out how they were going to go see a doctor. Like I couldn't provide that for them. Like the expense for that is just way too high. You know, they're using their own vehicles unless they, you know, we had to take a van someplace with a bunch of paint equipment in the back, you know, a spray or whatever. But like, it's not like I didn't have like a fucking eatery. You know, I didn't even have a shop for everybody to like come back to and like do brush cleanings or whatever. Like we did all that shit on site. You know what I'm saying? Like when you're just getting going, it's like you're writing shit like something like that, dude. Like these guys got like $100 Chromebooks and shit that they're trying to code on. You know? And then there's like 1 or 2 halfway decent PCs in the back or something that they're like able to like fuck around on for a little while. You know, like it's not like they got conference room space and like you know what I mean? Like they're just a bunch of dudes trying to like make something work right. And they're probably all running off of like stock or like partial stock in the company, like on like, you know, 5% ownership or some shit, 2% ownership on a little piddly nothing in hopes that the game takes off so that they could actually like get something for their effort. And it's just, it's so weird. Or like they got a bunch of guys out of college, you know, maybe the last 10 people that they've gotten there are like guys out of school and they're just working as interns. They don't even have any fucking money. They're just in there like working, trying to get a little experience. And like, you know, maybe they get kicked a couple of bucks here and there. Like, you know, I pull in a kid to like pull some hay bales for an afternoon. I give him a 20 spot. You know what I mean? It's so weird. Okay. So we have a sir reply. And I haven't even looked at these, obviously. We have a sir reply to the intent of well, this is the intent of a sir reply. So we have a filed sir reply from Nexon. So we have the proposed dismissal request. We have the dismissal request from Iron Mace. Then we have the opposition to the dismissal from Nexon. Then we have a reply to the opposition from Iron Mace, which we read and fucking cracked me up. Then we have this. This is a sir reply. So this is a reply to the reply that Iron Mace had made from Nexon. And then this is their intent to file. That it intends to file a sir reply in response to their defendant's reply in support of the defendant's motion to dismiss on the forum non-convenience grounds. Okay? Then we have the actual sir reply. And this is what we need to, I guess, look over. We also have the plaintiff's opposition to stay discovery and why. So right now we are in pre-trial. We're not to discovery yet. By the end of this month, in about 9 days, they're supposed to have a meeting with the judge to say, like their side and show an outline of what it is that they intend to get for their evidence. Who they're going to talk to, witness testimony, what kind of documents they're going to need, and then how long and how much all of that is going to take. Cost-wise, time duration, the whole thing. And then Mingjun Park is a counselor, a supporting counselor, a counsel for Nexon. And he's, I don't know what this declaration is exactly about. But we will see what they have to go on here. Okay. So, defendants base their forum nonconvenience motion on a curated and misleading presentation of the facts. including that the pertinent forum selection clauses cover all disputes that relate to the agreements. The clauses constituted an agreement to bring any claims arising anywhere in Korea, and all relevant conduct occurred exclusively in Korea. Now that Nexon has exposed defendants' misleading premises, ooh, we're getting heated already, defendants attempt a do-over, submitting 4 new declarations on reply, including from 2 previously undisclosed experts. I mean, not for nothing, but we're not in discovery, and they didn't have to disclose that they went to experts. And I'm pretty sure that these guys didn't end up disclosing that they had who they had in their back pocket or whatever beforehand either. But whatever. Because defendants could have addressed these matters in their moving papers, but chose not to, so that their motion would be artificially appear stronger at first glance, they should be stricken. Interesting. Nexon would suffer prejudice if the court were to allow defendants a mulligan to which Nexon is not permitted to respond fully, including with respect to the following. So what they're trying to say is because the defendants didn't let them know that they had certain experts, and they didn't, in their original motion, submit all of the supplemental testimony declarations from certain people, that the plaintiff is asking to have all of their declarations vacated by saying that they weren't made aware that those experts existed in the first place, and none of that supporting evidence was placed in the original motion. I would personally argue that the reason why they brought those things up, they probably went to find an expert the moment that that stuff got called into question, and ended up using them as a result because of the stuff that Nexon said about them. Not because they were trying to make an ironclad motion at the start. They probably figured that the motion that they made was like good enough by just referencing case law and having declarations from the people that were actually named in the suit, as opposed to needing to address like language issues. But okay, jurisdiction in Seoul. In advocating Seoul forum selection clauses, defendants had the burden of proving they were subject to jurisdiction in Seoul. Instead, defendants misleadingly characterized the clauses as Korean forum selection clauses, and John's original declaration was carefully worded to consent to jurisdiction only in Suwon. Because defendants could have established they were subject to jurisdiction in Seoul in their moving papers, the court should strike John's belated non-objection to suit in Seoul. That's interesting. So, the attorney for Iron Mace in Korea is what they're talking about, saying that the defendants misleadingly characterized the clauses as Korean forum selection, and John's original declaration was carefully worded to consent to jurisdiction only in Suwon. Because defendants could have established they were subject to jurisdiction in Seoul in their moving papers, the court should strike John's belated non-agreement. But, like, it wasn't on the defendants to have to bring it up in Seoul, though. The defendants brought it up in Suwon because that was the local court. That was what was closest to them. That's the thing that makes the most sense. So I don't find this to be very relevant. And if anything, Nexon are the people that had the issue. And I've said this before. Nexon are the people that had the issue with the copyright infringement case to begin with. So in regard to Nexon's copyright and protecting Nexon's information and the contract that Nexon drafted, it would be on Nexon to sue them in Seoul, not the other way around. But inconsistent positions on Seoul jurisdiction. In advocating Seoul forum selection clauses, defendants knew they would need to explain the contradiction with their position in Suwon. I mean, I think that this is reaching. This is assumptive. They knew that they would need to explain the contradiction with their position in Suwon, which defendants stated in writing to the Suwon court that Seoul Central District Court was not the competent court with jurisdiction for a claim against Choi for stealing trade secrets, and orally that Seoul has no jurisdiction over the case, which is probably procedural, just like DMCA, although I have no idea. Maybe this is true. Maybe this is something that they pulled out of their ass just to like fuck with things. But this to me reads like the same thing that DMCA reads like, where you have to like say that Suwon court or whatever has jurisdiction and the other courts don't. John's denial that the defendants took an inconsistent position is belated and not credible. He fails to offer any way to reconcile defendants' statements in Suwon with this bald denial. That sounds like a hurdle they're going to have to get over. But I wouldn't be surprised if this is just procedural stuff, like the DMCA thing that they're arguing over with jurisdictional, preference or whatever. Scope forum selection clauses. Defendants' motion argued the parties intended the forum selection clauses to cover disputes related to the agreements, as that term is used in U.S. case law, and offered no other possible interpretation of the Korean language phrase. Instead of attempting to support their original argument, defendants advance a new theory from Professor Lee that the Korean words have a broad scope that cover this dispute. But Lee's one-paragraph opinion about what the parties intended is inadmissible ipsy dixit. He does not address Professor Suk's analysis that the agreements were directed to Park and Choi's employment, not post-employment torts, committed at a company that did not exist during the time of employment. I mean, they absolutely did. They have, though. And this is literally, like, this reads like a 5-year-old going, like, he did not say that. No, he didn't. But they literally have already, like, twice now. And they reference the exact case law in doing so. This is such a weird tactic. He does not address how Seoul could be considered the exclusive jurisdiction for the dispute when Iron Mace initiated litigation in Suwon and the defendants continue to argue that Suwon is the preferred forum. Because Lee does not advance the theory in the moving papers and because his declaration is not based on significant or sufficient facts or data, it should be stricken. This is weird. This is so weird. I mean, they did address this, though. They directly addressed, like, especially this section here, they directly addressed this twice. And they referenced the case law when they did so. Both Professor Lee and the defendant's new translator argue arising out of and arising under are not the most appropriate translation of the relevant terms. These opinions are irrelevant because they fail to address Nexon's attack on the defendant's original theory. Korean speakers do not distinguish between the concepts of related to and arising under in the same manner as United States case law. I mean, that's still kind of, I mean, like, this point in itself is, to me, this looks as though Nexon is really grasping. Because now, like, if anything, I feel like this gives the defense even more credibility, though. Because if you, like, just looking at this, right, the majority of this argument has to do with contracts drafted in Korea, in Korean, and has to do with language barriers between Korean and English. If anything, this lends credibility, in my assumption here, this lends credibility, in my opinion, it lends credibility to that of Iron Mace and wanting this to be placed in Korea as the preferred forum, because we're in pre-trial. They haven't even gotten to the point where they're showing outlines about what they're going to get for evidence, and they're arguing over a 2-word phrase in a contract that was drafted in Korean, in Korea, between 2 Korean parties. We're not even in the trial yet. And, like, this is going to be argued, like, every fucking page of documentation between these two is going to be argued about, like, what the appropriate translation is in certifying them. And it's going to, dude, this is going to be the most long drawn out shit show ever if it stays in U.S. court. It's going to be horrible. I want you to kiss me on the mouth. I'm going to kiss you on the mouth with tongue. All right. I'm going to lick your tonsils, Hutch. All right. I'm just saying. I'm aggressive. Thank you for the TLDR and talk. I couldn't watch it yesterday and just watch a YouTube video recap. Yo, hell yeah, Empire. Appreciate you, buddy. What up, Hutchie? Love you, baby. International jurisdiction. Professor Lee advances an argument that the forum selection clauses fall under international jurisdiction based on the flawed premise that the clauses were intended to cover post-employment tortious conduct. Iron Mace impacts blah, 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 rather than Choi and Park's employment in Korea. Professor Lee's opinion is unsupported by the evidence and contradicts defendants' original contention that this is an exclusively Korea-centered dispute. Because defendants knew they were seeking to enforce Korean contracts when they filed the motion, defendants should have included these lengthy arguments in their motion rather than reserving them for reply. Like, these guys are jumping the shark because they assume that the reply was them withholding stuff. And there's no proof that they were actually withholding anything. And I think that's kind of shitty of them. They're going to do this, though, right? Because they're going to be like, wow, we know that they were holding on to it. There's no way they weren't. When really it's just like, it looks like the arguments that Nexon were making came out of left field. It's like, you try to anticipate whatever your opponent's going to do, you know, as much as you can, but every once in a while they'll surprise you with something. So it's like, oh shit, all right, well, we got to go and get some stuff then. I mean, this isn't in Discovery. So, like, there's no reason why they have to show each other shit. I don't know, whatever. Source code production. Defendant's motion falsely claimed Korean judges were reviewing Iron Mace's source code. Rather than owning their mistake, on reply, defendants lash out and blame Nexon for defendant's lack of production and accuse Nexon of bad faith. I mean, not for nothing, but, like, the plaintiff's original complaint showed evidence saying that there were things under Project P3 copyright that were screen caps, images of Dark and Darker, and they tried to claim that it was Nexon property. in their original complaint. There's multiple images of Dark and Darker and Nexon claiming that it's their game and it's not. So, I mean, I think this is more like pot calling kettle black. Much love to you, brother. Yo, hell yeah, Hutchie. Yeah, they're still playing. Yeah, they're still playing their hand of poker for sure. Defendants motion falsely. Okay, defendants lash out and blame Nexon for defendants' lack of production and accuse Nexon of bad faith. Yes. Yeah, that. Yes. John declares that Nexon should have employed certain Korean document request procedures rather than seeking documents informally. Declares that Nexon should have employed certain Korean document request procedures rather than seeking documents informally. If given the opportunity, Nexon would have explained that the procedures John... I love this. Nexon would have explained. This is great, because they could preface this. Iron Mace could preface this by saying, if given the opportunity, Iron Mace could have explained. John cites... All right, the procedures John cites are not used in practice in preliminary injunction proceedings because parties usually submit evidence they have on hand, and because time is of the essence in preliminary injunction proceedings, the document request procedures are rarely used as they are too time-consuming. Oh, so it actually isn't that Iron Mace refused, it's just that Nexon didn't request them because in preliminary injunction proceedings, they couldn't be compelled. So, it's not that they can't be compelled, it's just they couldn't be compelled yet. But they said that they couldn't be compelled. So which one is it? Moreover, the procedures are likely inapplicable in merits in preliminary injunction proceedings to confidential source code, and even if applicable, the sanctions on defendants for noncompliance would be ineffective. Kind of like the sanctions placed on Nexon if they were ruled against would probably be ineffective, and Nexon would say fuck you and keep the DMCA up anyway because they're cunts. Defendants knew that they had the burden of proving Korea as an adequate forum, and their non-production of source code was hotly disputed. Rather than falsely suggesting they had already provided the Korean court Iron Mace's source code and manufacturing a distorted excuse for non-production in reply, defendants should have included their position in their moving papers. But this isn't about this, though. Like, they're arguing that, like, what Nexon's trying to do is argue that the Korean court is inadequate because the defense can't be compelled to provide source code, for instance, certain pieces of evidence. They can't be made to do it in preliminary injunction proceedings, in pretrial. And the U.S. could enforce an order saying that they have to produce that if it was tried in the U.S. But if that is the case, then Nexon themselves could be filing motions right now to make the source code be given up. If it was all that important, they could have filed a motion for preliminary injunction citing source code the day that they put in their initial complaint, and they didn't. Defendant's motion falsely claimed Iron Mace's source code is in Korean. On reply, Park submits another evasive declaration claiming Iron Mace's programming notes are in Korean without taking a clear position on source code. So you don't want the programming notes? Park's testimony on whether the contents of source code and programming notes are in English or Korean is inadmissible. But what? So the actual source code being in certain nomenclature, right? Like using English. But the notes that are going to be all throughout that thing. So everybody understands, you have the actual code for a program, right? Like there's the actual programming language that is used to make a program, make the game in this case. And then you have notes that are placed in line with those bits of code. Usually so like future programmers or the existing programmer can go back and read the notes that are written so that they gain an understanding of what was being done as it was being done, right? It's a way for like future coders to be able to understand what was being done in those sections, right? If all of those sections are being written in Korean, you still have to translate them. So it doesn't matter whether or not the actual code is in a certain language, English or Korean. If the notes themselves are still in Korean, they're going to have to get translated. That's still going to take time. To be fair, 9 out of 10 times you still don't understand it based on notes alone. There you go. And it also comes down to the quality of the programmer and whether or not they're going to end up being rather descriptive or not, right? Like, because you could notate anything. I mean, some guy could end up writing a thing for bunny hopping in a game, diminishing returns on subsequent jumps, and they could just write Cheetos as like the note, and you're like, what the fuck? They could be anything. Park's testimony on whether the contents of source code and programming notes are in English or Korean is inadmissible. I don't think that that's true at all. Defendants have the burden of establishing a clear showing of facts entitling them to dismissal. Defendants' sandbag declarations cannot meet that standard and should be stricken. Huh. Sounds like there's going to be some oral arguments. Oral argument requested. Note on motion calendar, Friday, July 14th. Yeah, so that was the original motion. Okay, plaintiff's opposition to motion to stay discovery. So now they're trying to oppose the staying of discovery. So the defendants also put in a motion requesting that discovery is stayed, meaning like it gets delayed, in order to be able to figure out whether or not the motion is going to go through. Like, why bother going through the steps of discovery and getting all the evidence together if the motion passes? Simply put, defendants are seeking a stay to delay disclosure of critical information. This is not surprising given their refusal to produce source code for their darker game in the Suwon injunction proceedings in Korea. But they didn't refuse. They didn't refuse, though. They didn't refuse. Nexon never asked for it. And all this amounts to is the stage in the trial that they're at, not whether or not you could get it. And it is consistent with their litigation strategy in this action. But their litigation strategy is just following the rules. Nexon could just stop being baby back bitches and request it. Defendants filed a motion to dismiss the complaint of plaintiff Nexon Korea Corporation on forum nonconvenience to avoid U.S. discovery and consideration by U.S. court, blah, blah, blah. Before staying discovery, courts take a preliminary peek at the strength of pending motion to estimate the likelihood that dismissal is a foregone conclusion. Defendants do not address this factor at all, nor any of the arguments in Nexon's FNC opposition explaining why FNC motion is likely to be denied. Well, that's not at all true. I think that they punched a shit ton of holes in the argument that Nexon made. Defendants simply speculate their FNC motion might be granted, which falls far short of the good cause standard for staying discovery, in Nexon's opinion. See, like, at this point, I think the only people that believe that the motion isn't possible to be passed is Nexon and their own attorneys. I'm pretty sure. And this looks to me like a Hail Mary run, if anything. Courts do not typically stay discovery pending resolution of a foreign nonconvenience motion because such motions are not case dispositive. They change the forum but do not end the dispute. That is the case here because defendants only seek to move the parties' United States law dispute to Korea, not end it. Well, if it get vacated for forum nonconvenience, it's still going to get vacated. Vacated is vacated. Defendants also mischaracterize their FNC motion as raising only strictly legal grounds for dismissal, but the parties sharply dispute numerous factual issues. Defendants' reply in their FNC motion effectively admits that the alleged factual basis for that motion is entirely in dispute by purporting to submit multiple new declarations on reply to clarify, explain, or outright contradict defendants' own factual representations in their moving papers. Except, I'm pretty sure that when the plaintiffs replied, they did so using experts and stuff that weren't declared in advance either, but whatever. Finally, granting a stay significantly prejudices Nexon because it delays a case that requires prompt resolution. Defendants, on the other hand, will suffer no significant prejudice from denial of a stay. The task leading up... Wait. Granting a stay significantly prejudices Nexon because it delays a case that requires prompt resolution. For an IP that isn't being marketed, would not be marketed by Nexon at all, ever, for a company that's worth $32 billion, that prejudices them? In what way? How is Nexon being harmed by this? I don't see how Nexon is harmed by this at all. The task leading up to submitting a joint discovery plan, Rule 26F, conference and exchanging initial disclosures are not burdensome. So what they're trying to say is the joint discovery plan in that meeting that goes around that at the end of July is not going to be burdensome. Which I kind of agree with. I think that's true. Having a meeting about it and talking about what the plan is isn't bad, but they still have to come up with an outline to give the judge. So that is going to take some time. Because defendants have failed to establish good cause for delaying resolution of the case, the court should deny their stay motion. I mean, if it gets kicked to Korea, I think that's a pretty good reason. Nexon's a video game developer, blah, blah, blah. Background. Defendants purposely targeted marketing targeting the United States. Digital Millennium Copyright Act. I think this is pretty much just a carbon copy of shit they already filed. Contrary to their position here, Iron Mason initiated litigation Suwon, not Seoul. Defendants firmly took the position that Suwon and the Seoul court lacks jurisdiction, which is probably procedural, like I said. That's probably something that they had to declare in order to have it heard in Suwon. Nexon submitted expert testimony on how the forum selection clauses would be understood by Korean speakers in courts. Nexon has submitted expert testimony on how the forum selection clauses would be understood by Korean speakers and courts, which establishes the clauses do not cover this dispute. I mean, I don't know if that's true, man. Like, because what their argument is that, like, all this stuff could be provided electronically. It would be pretty easy to coerce people into testifying, you know, all that stuff. Like, the testimony and everything would be easy to obtain. Obtaining it is one thing. Having it translated into English, certified as being translated, certified accurate in English, especially when both parties are already arguing over a single two-phrase thing already, and it's not even gotten that far, is kind of wild to me. And to think that they aren't going to argue over every page, especially Nexon's attorneys, because they know that they have a blank check and they got billable hours to the ends of time. It amazes me that they would. Well, it doesn't amaze me that they would make this argument. It would amaze me if the court agreed with this argument to say that it won't be significant in time and expense, because it absolutely will. There's no way that it won't be. They're going to be arguing about every phrase on every page as much as they possibly can. The briefs invited by the court on the parties' preliminary injunction applications and sue-on are due on or before July 19th. After which, so this is what they're talking about. They reference Mingjung Park saying that it was going to be July 19th, which we already know because there was a news article about it, yesterday? After which the parties will await the court's decision. Nexon anticipates a decision within 1 to 2 months. There are no hearings currently on calendar in the sue-on merits litigation between Nexon and Iron Mace. Okay. Nexon filed a complaint in this action alleging copyright infringement and trade secret misappropriation under United States law. Iron Mace submitted DMC a counter notification. Iron Mace consents to jurisdiction. Yes. Defendants do not contest subject matter and personal jurisdiction. Defendants do not contest subject matter or personal jurisdiction, nor do they argue Nexon fails to state a claim. Instead, on June 22nd, defendants filed their FNC motion. Nexon filed an opposition. Defendants have also not filed a motion to dismiss for improper venue. So they need a forum nonconvenience motion and a improper venue motion? I don't think that that's true. This court has set a deadline of July 26th for a 26F conference, August 9th for initial disclosures, and 23rd for a joint status report on discovery. Defendants have now moved to stay these deadlines and all discovery pending resolutions of the FNC motion. All right, so the staying deadlines and pending the resolution of the FNC motion, defendants continue to express plans to release a final version of Dark and Darker in the United States. Yeah, they do, because they haven't had an injunction. Of course they're going to. Okay, mandate of showing good cause is critically important because Rule 1 of the Federal Rules of Civil Procedure provides that rules should be constructed, administered, and employed by the court and the parties to secure just speedy and inexpensive determination of every action and proceeding. But it won't be inexpensive. Thus, although a court may relieve a party from the burdens of discovery while a dispositive motion is pending, this is the exception and not the rule. Again, I find it hard to say that it won't be expensive when they're already arguing over the certification of a single paragraph worth of documentation really over a 2-word phrase, and it's not even gotten to discovery yet. And there's 5,000 pages, the majority of which are in Korean. How are you going to argue that it's not going to be expensive when you're already arguing over a single sentence in a single document, and you've been doing it for 2 weeks? In deciding whether to impose a stay pending disposition of a motion, courts consider whether the pending motion would dispose of the entire case and whether the pending motion can be decided without additional discovery. I mean, the motion would dispose of the case, though. So, because if it gets kicked to FNC, right? If the forum nonconvenience motion passes, it's going to Korea. It doesn't stay in the United States. Nexon never made a game acting like they made one. Yeah. Well, that's a good point. Like, they were making a game, but the game isn't made, and it wasn't ever marketed. They never made any money on it. So I don't see how they are more burdened than Iron Mace is when they're a $32 billion valuation and they're making money hand over fist on games like Dave the Diver. The court's preliminary peek into pending motion to dismiss is not intended to prejudice the outcome in motion. Courts take a preliminary peek at the merits of the dispositive motion to see if it appears to be clearly meritorious and truly case dispositive. Courts consider whether the complaint is utterly frivolous or dismissal is inevitable, rather than staying discovery in any case which a purportedly dispositive motion not requiring discovery is pending. Here, defendant's FNC motion is not meritorious. I don't think that's true at all. It's bullshit. Much less clearly meritorious. Again, I don't think that's true. Moreover, if it were granted, the FNC motion would not dispose of Nexon's claims. Rather, it would result in only Nexon refiling its claims in Korea. Which, again, the United States doesn't give a fuck about. If Nexon refiles the claims in Korea, why does the United States care? So refile them in Korea. That has nothing to do with the United States. Defendant's FNC motion is not clearly meritorious. Defendant's FNC motion should be denied on numerous grounds described in Nexon's opposition. The DMCA contains special venue provision granting Nexon the right to sue in the Western District of Washington. When a statute contains a special venue provision, forum nonconvenience is unavailable as a basis for dismissal. But it doesn't contain a venue provision. We already covered that. There's case law citing forum nonconvenience not being considered in DMCA trials or in copyright trials in general because it's not a declaration of forum, it's a declaration of personal jurisdiction. I think these guys are really warping this, like, really badly. Because that's already been covered. I mean, like, it's by the letter, like, you can read it. In exchange for availing itself of the privilege of invoking the DMCA counter-notification process, Iron Mace consented to this venue, but they did not concede to the venue. A bargain for consent to a venue should be enforced in all but the most exceptional cases. And then, again, they cite Atlantic Marine. That's so weird that they're citing the same case that Iron Mace is citing, and they're arguing it in opposite ways. Defendants seek to require Nexon to litigate and sue on district court based on forum selection clauses they misleadingly characterize as Korean forum selection clauses, but the clauses they rely on cover litigation in Seoul Central District Court and in Korea. So sue them in Seoul. Defendants affirmatively took the position in Seoul Central District Court lacks jurisdiction. Yeah, over a suit trying to get you guys to stop pursuing the DMCA injunction against them. That's all. It had nothing to do with the actual copywritten shit. Thus, by their actions, defendants effectively conceded the forum selection clauses do not have the meaning defendants have advanced in their FNC motion. I still say that the burden is on Nexon to sue them in Seoul. It's not on Iron Mace. The forum selection clauses defendants rely on do not cover this dispute. Defendant's contrary argument relies on cherry-picking possible translation of Korean terms into English. You mean the most appropriate terms into English by giving a 30-year tenured professor. They actually don't even attack whether or not the guy's an expert or not. All they did was attack not the validity of the statement being made. They attacked the timing because they can't attack the validity anymore because they know that the guy that translated it knows more about the Korean language and translating the Korean language than the dude that they tapped for the document that they did, for the declaration that they provided. So all they're doing is saying, rather than attempting to ascertain the intent of the parties, so they're saying like they cherry-picked possible translations, but they didn't actually cherry-pick them. They gave the most appropriate translation. And then these guys are trying to attack when it showed up by saying, well, they blindsided us. Like, why would you... So here's a good question. Why would you need to defend the translation of a document unless someone else called it into question? You wouldn't, right? Why would you have to, like, you wouldn't create, like, I wouldn't be shielding myself from an argument made by a party if I didn't know that the argument was going to be made until after they made it, right? So, like, it's a, I don't understand what the fuck they're saying. Proof of infringement of source code requires a side-by-side comparison of Nexon and Iron Mace's source code. But defendants have failed to produce their source code in Korea because it was never requested, and Korean court cannot effectively compel them to do so. Again, because you didn't request it. Nexon didn't request it, and there's a process in there that Nexon doesn't even dispute that the process exists. All they said was that the process is time-consuming, and the process isn't typically done in preliminary injunction proceedings. But after it gets past the preliminary injunction and it starts getting set up for trial, then they could probably compel them to do it, and they'd have to provide it. So it's not even that they can't get it. It's just that they couldn't get it yet, or didn't get it yet. Just didn't get it yet. It's still provided. It just isn't provided at this point in time because they didn't ask for it and because the court doesn't typically do it. This is such a weird take. Korea doesn't offer Nexon an adequate remedy at this point in the trial. So this is literally Nexon just being like, we're impatient. Defendants purposefully targeted the United States for copyright infringement. They targeted the United States for marketing, even where the alleged copyright infringement, even where the majority of witnesses and evidence are located overseas, the Ninth Circuit has held copyright cases concerning alleged unlawful activities purposely directed toward the United States are more amenable to suit in the United States. So, at the last playtest, 30% of the people playing the game were in the United States. That's absolutely true. 30% of the people playing the game were in the US. In the SEA, which Korea couldn't be a part of in the very last playtest, in the SEA, there were another 30% of players in the SEA, and then the rest were made up between like Europe and Asia, like Western Asia and Europe. During the playtest where Korea was allowed to, not the one for uTorrent, but the other, like the one before that, where Korea still was allowed to take part in it because it was still on Steam. The United States was like 32, 33%. They were like a third. But then there was, again, another third was made up between like Korea, Japan, China. You know what I mean? Like, it's not like it wasn't a global thing. It's just that the United States, typically as a market, is the one that spends the most money. Also, partially because the United States has like a pretty large population, right? And per capita, the United States usually has disposable income to spend on games. So, of course, they're going to go to the Western market because people in the United States spend money on games. There's ordinarily a strong presumption in favor of the plaintiff's choice of forum. There's ordinarily a strong presumption in favor of the plaintiff's choice of forum, making a grant of forum nonconvenience motion a rare occurrence. Because several premises, so they're saying like usually where the plaintiff wants to argue it is where people end up in the United States. Which is kind of a weird take considering that like, I don't even know what cases that they're arguing, or what they're pulling here, HDT Biocorp, this case. I don't know what this case entails. I wonder if this is a case that they're referencing from an overseas source or not. Because several premises of the defendant's motion were misleading or false, defendants were required to submit 4 new evidentiary declarations, which are subject to a motion to strike. Yes, there's a motion to strike, which I hope to God doesn't get granted, because if it does, that's shitty. Because again, I think Nexon is just being cunts. Defendants fail to address the preliminary peak factor and instead simply speculate their FNC motion might be granted. But a defendant's speculation that its motion might be granted does not satisfy Rule 26C's good cause requirements. In light of the numerous and significant questions with respect to the merits of defendant's FNC motion, defendants cannot establish good cause for a stay. I mean, I disagree. I'm not a lawyer or a judge, but I think that Iron Mace made a very, very compelling argument, and I think that Nexon's argument is fucking weak as hell. I think it's super weak. They filed in the U.S. because the laws are written in a way that could be more favorable to Nexon. Well, no, they filed in the U.S. because they had to. In order to be able to take the game off of Steam, they had to file the DMCA request in the United States because it's United States law. Just like if somebody files a DMCA request on YouTube and YouTube takes that down, they're doing it citing a United States law. They have to argue United States law for a United States law being invoked, right? Like it's not like Steam is going to recognize the authority of a court in Germany because Steam isn't in Germany. Steam's in the U.S. Now they could recognize the request in Germany for Germany, only in Germany, but it would have nothing to do with the rest of the world. If they file it in the US, though, it hits it at the root and it gets taken down for everyone. They completely remove it from the platform instead of just blocking a certain country. Defendant's stay request fails on the additional ground that unlike Rule 12b-6 motion that established a plaintiff has no valid claim against the defendant, forum nonconvenience motion simply moves the case to a new forum without disposing of it. When a motion to dismiss does not challenge the merits of a plaintiff's claim, but rather relies on forum nonconvenience, this factor does not weigh in favor of granting a stay. Now, that could end up actually carrying some weight. So they're saying that just because you're arguing that the forum isn't convenient doesn't necessarily mean, based on prior case law, that that would be something where you would grant a stay, where they would put the discovery process on pause. In this case, the stay was denied because in the event the court dismisses plaintiffs' claims against Thorco Projects, plaintiffs will need to pursue the same claims against Thorco Projects in the London arbitration. In the event the court dismisses plaintiffs' claims, Plaintiffs will need to pursue the same claims against Thorco projects. So, but here's the thing with this though, right? They're talking about like needing to do discovery. And I think the argument here would be, they're saying that if they dismiss it for form nonconvenience, it's still going to be argued overseas in the Korean court. But the Korean court is already ahead of the United States court. The evidence in the Korean court has already been, for the most part, collected in terms of like the discovery process and this injunction procedure that they're going through. The evidence that they've submitted has been submitted, or they're submitting has been submitted. It was done as of yesterday. So I don't know, and again, I feel like this might be a reach, because I don't know how it's handled if the evidence is already, like, with the court. Then what? Because this sounds like it was worded in a way where the United States court was at the same point as the London arbitration was, or ahead of it, and the plaintiffs needing to pursue the same claims against them in the London arbitration. Like, in my mind, that makes it sound like the United States court was ahead of the London court, whereas it's the opposite now. The Korean court already has everything that they want, with the exception of the source code, which again Nexon could request and didn't. In Turner, the defendant moved for a stay pending the court's consideration of the defendant's motion to dismiss. Italy was a more convenient form. The court denied the stay motion because even if the court were to grant defendant's form nonconvenience, the need for discovery would not be eliminated. Discovery would only be delayed because plaintiff would be free to refile the case in Italy. But the case has already been filed in Italy. Or in this case, the case has already been filed in Korea, and the Korean court is already ahead of the United States court. This isn't like would need to refile. And what Nexon's going to argue is that they would have to file in Seoul. If it got ejected, Nexon would have to file in Seoul, is what they're going to argue. So fucking do that. But you're already fighting over the same exact case in the Suwon court, which you would just end up using the same exact evidence that you've already collected and handed to the Suwon court. So again, I don't see where there's a burden here. Similarly, defendants do not challenge the merits of Nexon's claims. They don't contest that Nexon has stated valid claims for relief on both copyright and trade secret claims. Even if the court were to grant defendants' FNC motion, Nexon would be free to refile its United States claims in Korea despite the inadequacy of Korea as a forum. So, fucking do that. You're already fighting over the exact same case in Korea already. So just refile it in Seoul. Defendant's characterization is granting a stay because of a pending form nonconvenience motion is false and misleading, while the court the form nonconvenience argument is irrelevant to the court's decision on this issue. So they are referencing a bunch of case law by saying that it shouldn't be delayed because a lot of other cases didn't delay it that had to do with form nonconvenience rules. But I don't think that they're really close enough. Defendants also mischaracterized Melbastad versus City of Cascade, Ohio. Granting a stay pending a form nonconvenience motion, the defendant in Melbastad did not move to dismiss on form nonconvenience grounds. The defendant moved to dismiss for lack of personal jurisdiction. The pro se plaintiff responded by arguing Nevada was not a form nonconvenience and the plaintiff failed to oppose the stay motion. While Melbastad noted that the stay may be appropriate if a motion raises issues of jurisdiction, venue, or immunity, defendant's FNC motion raises none of these issues. Unlike jurisdiction, venue, and immunity motions which attack the legitimacy of the court, even considering the case of form nonconvenience dismissal is a strongly disfavored discretionary tool for dismissing claims that are properly before the court. Because the defendant's FNC motion can only change the form rather than dispose of the litigation, this factor does not favor a stay. Issues of jurisdiction, venue, or immunity. The defendant's FNC motion raises none of those issues. Unlike jurisdiction, venue, and immunity motions which lack the legitimacy of the court, even considering the case, a form nonconvenience dismissal is strongly disfavored discretionary tool for dismissing claims that are properly before the court. I still don't think that they made a strong enough argument here, though. I think that their argument is weak as shit. The FNC motion raises factual issues. Showing a lack of candor at the same time defendants were drafting 4 reply evidentiary declarations disputing facts because Nexon called them into dispute. Defendants submitted a stay motion characterizing their FNC motion as strictly legal. In reality, the parties dispute a number of factual issues, including the meaning and scope of forum selection clauses where the defendants are stopped from asserting them, the language in which critical documents are written, where the United States litigation is beyond the means of defendants' financiers, and the location of third-party witnesses. I don't think that they said that it was beyond the means of the defendants' financiers. Maybe they did say it was be a financial burden to Iron Mace. I think they just said that it was going to be hundreds of thousands of dollars. Denying a stay where motion did not raise pure legal questions. While the court should simply strike defendants' reply declarations and deny the motion, you should strike these. On the grounds that defendants have failed to meet their burden, even the reply declarations were considered. Defendants are incorrect that a forum nonconvenience motion is one of which discovery is barred. Denying forum nonconvenience pending discovery, okay. The court should deny on the additional grounds that the prejudice to Nexon from granting a stay far exceeds any potential prejudice to defendants from denying it. Defendants seek to delay not only the commencement of discovery, but the parties' Rule 26 meeting and conference and subsequent report to the court, thereby, in effect, staying the entire case because nothing can move forward except pleading issues until case deadlines have been set. Defendant's request negatively impacts the court's efficiency by delaying preliminary proceedings necessary to move the case forward in a timely fashion. Furthermore, a stay of the entire case is prejudicial to Nexon because defendants are continuing to develop an infringing game whose development was accelerated through use of Nexon's trade secrets. Just last week, for example, defendants posted on YouTube a first look at a Warlock character, which had nothing to do with the source code from Nexon and was never even discussed in Nexon's studio. Thus, any delay in the proceedings increased the likelihood that defendants will begin selling a complete version of the game before the court can resolve the dispute. The need for a prompt resolution in this case strongly mitigates against this stay. I hope to God Iron Mace finds a way to make $5 million on this game, if only then to waggle their dicks by lifting their kilts up at Nexon from afar. Just, I want them, dude, I want them to make so much fucking money on this and just laugh in Nexon's face. There's a reason to avoid delays in the litigation if possible, and a stay of discovery at this time may be contrary to the interest of justice. See, here's the thing, though. All of this shit that Nexon is trying to argue is literally just padding the wallet of the attorneys at the law firm. The guys at Stokes Lawrence are looking at this as billable time. If the injunction in Korea were granted against Iron Mace, because they both are seeking preliminary injunction against each other, if the court in a month, 6 weeks, whatever, comes back, it's like September, and the court comes back and says, Iron Mace can't do business on this game anymore. You have to stop. If they issue a preliminary injunction, none of this shit matters. It all goes to shit. Because if they can't work on the game in their office because the Suwon court told them that they couldn't, that's it, right? Nexon pushing this ahead basically shows or reads in a way where they are desperately trying to keep litigating this in the United States, not only because they're trying to run the meter, but also because they probably figure that the Korean case is weak as fuck. Because if it were me, I'm looking at this like, well, yeah, this needs to advance or whatever. I can keep running the meter up. We're going to go into discovery, and I'm going to have thousands of man hours. I'm going to have 20 lawyers running at $500 to $1,000 an hour on billable time. I'm going to make myself $600,000 in a month. Like, that's what these guys are looking at doing because they want it. They want the money. They're looking at the billables. You know that they are. Internally, they're talking about this like this needs to go to discovery because, oh my God, cha-ching. You know they are. And at the same time, they're outright ignoring that this Korean ruling, even a preliminary one, if it's against Iron Mace, means that the entire thing stops and Nexon basically wins because they can bog this thing down because the trial proceedings wouldn't happen for another 2 years. So if Nexon gets the preliminary injunction, you know, pending appeals failing and all that stuff and motions to the court and, you know, all that. If that happens, Iron Mace is fucked. Dark and Darker is fucked. And they won't know whether or not they're going to end up actually seeing this game ever coming back again for 2 to 3 years. Right? Because of all the litigating that would need to be done. It just really reads weird to me that these guys are making this Hail Mary play on a United States case where they're like, Korea isn't appropriate, but we're arguing in Korea right now and it's ahead of this case anyway. It just seems so strange. They must think that the case in Korea is weak. That's the only thing I can think of that would make them want to be like pushing it this hard. If the court rules an FNC motion within the next month, defendants will need to engage in Rule 26F conference, serve initial disclosures, submit a status report, and discovery plan. None of these activities impose a significant burden on the defendants. I mean, aside from the fact that they're going to need to start gathering evidence and talk about it, like what they're going to gather, and it's still going to have to be translated from Korean. You got 5,000 pages of Korean documents. Even if the court takes longer than a month to rule on the FNC motion, and even if the court were to grant the FNC motion, defendants would still not suffer material prejudice because such a ruling would only change the forum, not end the litigation. Because there's a need for prompt resolution of this dispute, regardless of whether that resolution occurs in the United States or Korea, there's no good cause to put the case on hold while the forum determination is made. Nor is there a likelihood that discovery will result in any duplication in the coming months. In the Suwon litigation, the parties are scheduled to file their briefs and preliminary injunction on or before 19th. After the 19th, the parties will wait for approximately 1 to 2 months for the court's ruling on the parties' preliminary injunction applications. No further proceedings are on the calendar in Korea. There's also no likelihood the parties will retread what has already occurred in Korea. No witnesses testified in Korea in the parties yet, and the parties did not engage in anything resembling document discovery yet. Rather, the parties submitted written briefs along with evidence they already had in their own possession, because it's a PI hearing, and it's going to move to trial after this. Furthermore, the parties in Korea have only litigated issues of Korean law. Why would they litigate anything else? No work has been done on issues of United States law. Thus, any discovery taken will not be a redo of what has occurred in Korea. Why does Korea give a fuck about what the United States law is? That doesn't make any sense. And again, you're attacking the root here, though. If they end up going after, if the Korean court determines that Iron Mace can't continue to do business, it just ends. How are they going to continue generating a game? They'd have to move to a different country. I think they'd have to see that happen first. Moreover, if the court denies defendant's FNC motion, which is likely given its numerous defects, the stay would prejudice all parties by imposing an unnecessary delay in resolution of the dispute. So weird, man. Defendants contend they're cost-conscious defendants who will settle an anemic case to avoid discovery is contrary to the evidence. Choi has stated he obtained financing to develop Dark and Darker. And those financiers have supported a team of 30 full-time employees, apparently for more than a year, even with no significant revenue coming in. The evidence is clear that the defendants are backed by deep pockets. What? And defendants, despite submitting 4 evidentiary declarations on reply, have submitted no evidence that litigating this case pending determination of the FNC motion is outside the means of their deep-pocketed backers. By failing to move to dismiss for failure to state a claim, defendants have effectively conceded Nexon's claims past the threshold for meriting discovery and are not anemic. So, to be clear, because the defendants say that they don't have a lot of money, Nexon's argument is they have to because they have 30 people working at the studio. Now wait, just to be clear, this is the same company that produced evidence that was screenshots of Dark and Darker, claiming it to be Project P3 when it wasn't, in multiple places. They also submitted evidence to say that Terry Park was a resident of California and had a house in California in their original dispute, even though Terry hasn't been in California since he was a kid and moved to Korea like 15, what do you say, 15 years ago? He was born in California. He's a citizen of the United States, but he hasn't ever owned any real property in California ever. So we have a company that is openly making assumptions about the defense and allowing their attorneys to state as such when we already have a proven track record of those assumptions being completely fucking wrong. And they're making Swiss cheese arguments here that directly go against prior case law that has been cited chapter and verse that they have not yet, like the forum nonconvenience thing with roping in Iron Mace as party to the contracts that were drafted for Choi and Park. We have prior case law that happened in the Ninth Circuit that was litigated in the Ninth Circuit, where this case is being litigated, that was relatively recent, that is almost a carbon copy of this case in terms of like IP dispute and all that stuff. Guys starting a company after they left the company and took IP with them and the whole thing, and they included the company in the case for the exact reasons that Nexon is saying it shouldn't be included. And Nexon still hasn't referenced that case and tried to argue against it at all, or shown prior case law to say that there's a reason why it shouldn't be included. They're just saying it shouldn't. Like, and it's not, and they're saying that Nexon Like, Nexon has their own money, right? They're a $32 billion company. Everybody knows that Nexon has their own money. They know who their investors are. Nexon's a publicly traded company funded by other publicly traded companies. And then they're basically saying, like, no one knows what Iron Mace's books look like. They have an independent, like, third-party financier. Like, they have an investor or investors. Therefore, those investors clearly are funding them with unlimited funds. Because there's never been a limit placed on funds given to a company when somebody's invested into it ever before. Right? Like, what the fuck? And because they don't know who those people are, how much money they've gotten, they're just making the assumption that this financier or multiple financiers have given them, like, carte blanche and they can just spend as much money as they want to. Because they have a 30-person dev team working out of an old BJJ dojo that's owned by Terry, where they started sitting on, like, the mats on the floor with laptops and trying to code their game. Like, I don't know, man. Like, what is... They had, I mean, Project P3 over a year and a half spent, like, what? What did they say? Like, 850 grand for a 12-man dev team? Including, you know, all of their billables, like, you know, keeping the power on and, like, the computer terminals they provided and the server hosting and all that other shit, right? So if you have a skeleton crew of 30 people, and it's only 30 people as of, like, the last couple of months, right? Like, it was 22 people a year ago when I interviewed Terry. Not even a year ago. It was 22 people 10 months ago. So if it was 22 people and now it's 30 and they haven't made a penny, like, how much runway do you get? You know? If they had $500,000, right? Let's say they had 500K of runway. That's not unlimited cash. They would exhaust that money. Like, in the process of discovery, that would evaporate. That would evaporate like, dude, that would evaporate like water poured on the fucking Arizona desert. At noon. That would be gone. Like, just $500,000 would be eaten up in days. Like, like, the assumptions that are being made in this, like, they use language like they knew that, or like they must have. Well, and here's the other thing. Here's the other thing too, right? They are basing all of this. They are basing all of this on a declaration made. They're basing all of this on a declaration made in a meeting or a series of meetings where they're saying that SDF told his coworkers that he had outside financing to pursue his own game. They don't know whether or not that financing stuck around after Nexon decided to file suit on a DMCA claim against them. Because if I'm an investor and I'm looking at a game like Dark and Darker, like, oh shit, man, I could, like, throw some money at this. We could make some fucking money, right? Like, if I'm a producer, if I'm a producer or publisher, and they need, like, a little bit of an extra push, yeah, dude, I'll give you $500,000. Let's fucking make this thing, right? And then the DMCA claim comes in, and you're like, oh no, bro, like, we're not doing that. Like, I need return on investment. Like, if I'm not gonna see my money back for 3-4 years, if ever. Like, I don't know whether or not your case has any merit. I'm not gonna throw money at you anymore. Fuck that. Like, you had money, but now we're not doing that anymore. I'm pulling it. There's no indication that they have any continuing investment at all. None. Other than the fact that they got a good attorney. Which, that could be coming out of Terry's own pocket. We don't fucking know. And all of that is hearsay. Like, they're basing this on a statement that they believe to be true and trying to submit it as, like, evidentiary support. Those financiers have supported a team of 30 full-time employees. I mean, they might have a little bit of runway cash, but to say that they can afford to, you know, pay through the nose for discovery in 2 separate court cases is insane. The evidence is clear the defendants are backed by deep pockets. And defendants, despite submitting 4 evidentiary declarations on reply, have submitted no evidence that litigating this case pending determination of FNC motion is outside the means of their deep-pocketed backers. Furthermore, by failing to move to dismiss for failure to state a claim, defendants have effectively conceded Nexon's claims past the threshold for meriting discovery and are not anemic. I mean, They're trying to goad them into sharing financial statements at this point, which is really fucking weird too, man. They're like, show us your books. Well, fuck you. Show us your books. Would it show us where you appropriated all the money that you were appropriating for the development of P3 then? The hell? Also have to provide they knew when and doing they have to define who they is. Is they the company or an employee? Did that employee notify company leadership? Right, yeah, exactly, man. Even if there was evidence that defendants' financial years were under a significant financial burden, which there is not, because there doesn't need to be, defendants claim that they need to translate thousands of pages of exhibits submitted in Korean proceedings costing hundreds of thousands of dollars, if not much more. It's grossly exaggerated. Some documents, such as the parties' DMCA correspondence, were originally prepared in English. Okay, the DMCA correspondence was 10 pages. Other documents, at most. Other documents, such as extensive discussions of Korean copyright law, would be of no value to either this court or a jury. Translations of other documents can be limited to relevant portions. What's relevant? For example, the portions of Nexon's employment policies referencing confidentiality obligations may need to be translated, but defendants have shown no need to translate all employment policies. Why would they need to? That doesn't even make sense. Defendants have shown no need to translate all employment policies. Well, wouldn't that come out? What? This reads so weird to me. They're like, why haven't they thought of every single possible angle that could ever have been thought of at this point in the trial when they're arguing about whether or not we even need to have one? They should have shown us a bolded list of everything that they intend to argue and why they need to argue it. Isn't that exactly what the meeting is supposed to be for when they talk about like the pre-discovery binders and shit that they're supposed to be putting together? So this is such a weird way to go about this, man. It's like they should have been arguing things that are 2 steps in this process ahead of where we are right now in order for us to be okay with what it is that they're arguing. It's so strange. While none of the defendants' U.S. legal team may speak Korean, defendants clearly have bilingual people working for them that can spare them the expense of paying for certified translation of irrelevant material. How do we know what's irrelevant? How does anyone know what's relevant or not? Wouldn't the defense be making up their own assumptions on what they consider to be relevant? Why is Nexon trying to speak for the defense on behalf of the defense by saying that the defense why does the plaintiff have an idea of what the defense would consider relevant or not? Isn't that up to the defense to decide? It's so weird. It's so weird. Again, this goes back to Nexon making assumptions in their original complaint. Like, Nexon's original complaint was the game was greenlit, and the reason why the team quit to make the game is because they knew how successful the game was going to be because of how successful Nexon had decided the game was going to be. Right? Like, Nexon knew the game was going to be a hit, and the guys quit because they wanted to get all the money for themselves, basically. Like, that has been Nexon's argument, was the game was destined for success. And the reason why the game was so successful and the reason why it was fast-tracked and the reason why the game took off is because Nexon knew internally that the game was going to be successful. Like, they apparently are the rubric by which all games are graded. And then throughout all of this process, Nexon has, and through their attorneys, their litigators, have tried to argue that Nexon knows the psychology of not only the defense, the legal defense, the attorneys in the defense, but also the defendants for their motivations behind whatever it is that they're doing. Like, you have bilingual people working for you that could spare you the expense of paying for certified translations of irrelevant material. But that's like Nexon trying to tell the defendants what's relevant to them. Just like the Nexon was trying to tell the court that a game was successful because Nexon determined it to be so. Like, the fucking God complex here is insane. Delaying commencement of discovery would only increase the likelihood that critical evidence would be unavailable once discovery begins. Defendants began concealing evidence when Choi deleted his personal service to prevent Nexon from concluding forensic audit of how he used the data he stole, which was well within his rights per the agreement that he signed of his employment that said that he was supposed to do that when employment was terminated. Like, that was something that was well within his rights to do and isn't and isn't currently illegal to do. Like, I would absolutely be pulling into question, like, why would you do that if you had nothing to hide? Then just show it to him, right? But if he talks to his lawyer and his lawyer's like, dude, you should just delete that shit, like, they could fuck you, right? Like, you're leaving a company on bad terms. Like I left like, if I leave my apartment, right? I have an apartment that I halfway trashed or whatever, and I say that I cleaned it up. When I leave, right? Like, I'm going to clean my apartment. I'm going to record fucking everything. But if I got a shitty landlord that I never got along with, that motherfucker is going to find every excuse he can to keep my security deposit. Because that's what landlords do. If I'm an employer, or if I'm an employee of a big company, and they're like, you committed fraud, you're a piece of shit, right? Like, get the fuck out of here. All right, well, fuck you, man. I'm just going to delete all the shit on my servers too, because I don't want you to end up saying anything more, like, shitty about me. Right? Like, if I don't want to get blackballed, I'm going to delete everything. Fuck all that. Right? And of course, they turn it around and they try to argue that it was him stealing. This is proof of him having stolen stuff because he wasn't forthcoming and didn't let us, like, pour through all of the shit that he had on his PC at home. And I think that that's kind of like a shitty position, man. Like, you're kind of fucked if you do, fucked if you don't. It's kind of weird, man. It's the whole thing reads like so grasping. Defendants continue to suppress evidence by refusing to produce source code in Korean litigation, which Nexon, and again, these guys only gave like one fucking blurb in their SIR reply to say that it was a time-consuming process. It takes a while. That's what they said. It wasn't that they couldn't get it. It's just that it took a long time. So what you're saying is that you're impatient, and this statement of them suppressing evidence by refusing to produce source code when you never asked for it is really fucking weird. Like, they tried to talk about it inside of, like, closed-door meetings on several different occasions where they didn't come to an agreement because Iron Mace wanted a third party to review all of the files, and Nexon just wanted them to give them to him. Instead, like, they were just like, we're going to give you ours, and we'll give you ours, you give us yours. And Iron Mace was like, no, we'll just have a third party review it. And Nexon was like, nah. So then Iron Mace was like, oh, okay, fine, fuck it, no deal. And then they're saying it's like, well, they failed to produce source code in the litigation, which they could have formally requested through the court. We have documentation to prove that. While defendants publicly claim to be committed to transparency, they have taken every step in their power to avoid letting the full truth come to light when brought to court. Because they don't have to provide anything that they aren't told that they have to provide. Why would I give them more ammunition? It's basically like saying, like, well, I asked you this question. Why didn't you answer all other questions that I could have potentially asked you? Defendants have hidden the evidence of their wrongdoing long enough. Defendants have not set forth any good cause for more delay. For the foregoing reasons, the court should deny defendant's stay motion. I hope that the judge takes this motion for the opposition. I hope that she takes this and, like, she ran out of 2-ply in the bathroom and she has to wipe her ass and she uses this to do it. Like, oh, I'm out of toilet paper. What can I use? And then she just grabs this and you're like, oh, yeah, this is basically the same thing. Because this is, dude, this is so reaching. They have, like, one good point in all of this. 20 pages. 20 pages of garbage fluff and, like, one halfway decent point. They have to know that this position is weak. There's no way that Blackburn doesn't know that this is a weak argument. He has to know that this is weak. Although I think it's Shannon Jost. I think it's Shannon Jost is the lead attorney, right? Stokes Lawrence. She has to know it's weak. And then Park is just talking about how the court has July 19th set as a date to deliver it. So yeah, I mean, that's kind of how it reads to me, man. It's a real strange bird. And I think that their argument's weak, but yeah. All right, well, we talked about it.